I want to give you a chance, but you don't seem to be taking this seriously.
I do, sir. It was just rough.
You had an opportunity to speak. Now it's my turn. Case number 24CR41909, the State of Ohio versus Deshaun Brinson. Mr. Brinson is before the court with his counsel, Mr. Wendell, Ms. Tranter, on behalf of the State of Ohio. This final probation violation hearing, Mr. Wendell, does your client wish to have a hearing?
Your Honor, we would waive a formal reading, accept the allegations, enter an admission, a plea of guilty.
All right, Mr. Brinson, you understand that you are entitled to have a hearing?
Yes.
You wish to waive that hearing and admit to the violation?
Yes, sir.
All right, the court's going to find that you have violated the terms of your community control. The only thing you want to say?
Your Honor, thank you. Judge, in mitigation, I think when you inquire of Mr. Brinson today, you're going to hear an individual that is upset that he let you down, and perhaps even more importantly, upset that he let himself down and didn't follow your orders. He accepts and acknowledges the wrongfulness of his conduct. I think, while certainly not excusing the behavior, I think when you inquire of him, it'll give some insight into why he did what he did. We would respectfully, and I know he's asked it of you in correspondence, request that he be restored to a period of community control. Judge, he is realistic, however, the severity and significance of his conduct, I know he does wish to address the court.
Mr. Brinson, anything you want to say?
Yes, sir. First, I'm gonna take accountability for my for what I did, but I think it was like I just was moving fast to get out. I was at a great auntie house that I just met when I was 15. So, and she was just basically all about money. So when I went there, you know, I was on house arrest still. I had to finish school, GED, and do the outpatient, so it was just a lot. But with her, she wanted money. Then she got to acting weird when I ain't had the money. Like she'd just make a whole meal and just say some weird stuff like, everybody eat before he eat. So, and then my cousin, I was doing good. I got a curfew. I was making it back. My cousin, said she was gonna come get me. The last 30 minutes came. She told me I had to find another way. But by the time I found another way, I was late. So that's when my Miss Fisher took my curfew away. So that day I just got mad and just lost it and just took it off. But the whole period of the time, I was just with my girlfriend in the house, chilling with the kids, just helping. I think if I can get another chance to get probation, I know I'll be all right.
Mr. Brinson, if you recall, when I sentenced you, the prosecutor's office wanted me to send you to prison. Anytime we have a failure to comply, they are always asking that I send people to prison. With you, I saw something in you. I really expected you to be compliant. I gave you that opportunity, but on this type of charge, you don't get a second chance, third chance. So at this time, the court is going to make a finding that you are no longer amenable to community control in the prisons as necessary to fulfill the purposes and principles of sentencing, including punishment, deterrence, and protection of the public. On the failure to comply, the court is going to order you to serve 24 months in prison. The receiving stolen property, I'm going to order you to serve 12 months in prison. And the obstructing official business, 12 months in prison. Those to be run concurrent with each other, but by law they must be served consecutive to the failure to comply. You have 121 days jail time credit at this time. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions, but there is still restitution owed of $700 to Maria Gonzalez. You're also subject to a mandatory period of post-release control, which means upon your release from prison, the adult parole authority may will supervise you for not less than 1 year nor more than 3 years. If you violate that supervision, you can be returned to prison for up to 1/2 of the court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. Ms. Tranter's, anything?
Judge, I just want to double check, you want an aggregate 36?
It's an aggregate, it's what has to be 24 plus, yeah.
Yeah,
It's an
okay.
aggregate-
I just want to
aggregate.
double check.
The other thing that I want to mention to you, Mr. Brinson, I would not be opposed, if you're sincere today, is to at least consider judicial release at some period of time after you've been placed into the institution. I want to give you a chance, but you don't seem to be taking this
I
seriously.
do, sir. It was just rough.
You had an opportunity to speak, now it's my turn.
Sir.
Yeah, I understand that. You know, the probation officer, and again, I'm just looking at the notes here. You cut off your monitor in January of 2025, and then you weren't arrested until, when was he arrested?
I believe he was booked into Warren County Jail on 11/21.
So for 10 months, you did nothing. You haven't completed any of my orders that I can see. So again, if you're having difficulty, then you reach out for help. You don't just make it worse by cutting off your monitor. That's the absolute worst thing you can do. So, but again, I will at least consider judicial release. You have to comply with the rules of the institution. Anything else, Mr. Wendell?
No, sir.
All right, that's all. Thank you.
In this case, what unfolded inside the Ohio courtroom illustrates the divide between judicial hope and judicial obligation. The court previously chose leniency, placing Deshaun Brinson on community control, a privilege rarely granted for failure to comply offenses, where prison is typically the expected outcome. That decision reflected a belief that he could comply, finish his GED, complete outpatient services, and demonstrate stability in the community. Instead, nearly 10 months passed with zero progress. He cut off his GPS monitor, stopped reporting, and lived outside supervision until his arrest. Under Ohio law, a probation violation is not only about the conduct itself. It is about whether the defendant can be safely and responsibly managed outside prison walls. Here, the judge determined he could not. The legal threshold, no longer amenable to community control, was met, triggering a statutory shift toward punishment, deterrence, and protection of the public. While Brinson offered explanations, unstable housing, family tension, financial pressure, emotional strain, the system responds to compliance, not circumstances, and compliance never came. Because of that, the judge ordered 36 months in state prison with only one narrow future possibility: judicial release, but only if proven through action, not apologies.